but the attorneys will intentionally put it into the will, knowing, well, okay, if they're smart enough to do a revocable living trust, at least we're getting something out of it, and we're expanding what we have to do for paperwork. Hi, Jeff Versace, the Plain English Attorney, and welcome to the video. Today we are going to talk about 6 ways that attorneys overcomplicate estate planning and get paid more for it. Unfortunately, this is a big thing that we see in the legal community. I review wills and trusts from other attorneys all over the place, and I end up seeing these trends of ways that attorneys are getting paid more. Now, either they're doing it unwittingly, or unfortunately, they know exactly what they're doing and they're trying to make more money off this whole process. So we're going to talk about these 6 ways. So the first 2 that we're going to talk about are at the planning phase. They're trying to get paid more. So I see this all the time. You end up with a couple of the basic documents, even if they're not talking about a trust, or they are. All right, if you've got that trust, you've got the will, you have the durable general power of attorney, you have the healthcare power of attorney, you have the nomination of conservator, you have guardians for any minor children, and they address each single one and they talk about, well, who do you want to do this? And here are the pros and cons. And they go through this. And meanwhile, the clock is ticking and they're getting paid by the hour. And they're drawing out that process.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Look, it really should be easy to plan this in a coordinated way that makes sense. Now, the way I talk to my clients is, look, you need to answer the big 4 questions in the planning phase. Who do you want to handle things financially if you end up in a coma for 6 months? Who do you want to end up in? Same question. And if you pass on, who's making sure that everybody gets what they're supposed to get and when? Second question is, who do you want making these healthcare decisions for you if you're in that coma for 6 months? The third thing is, how do you want your estate distributed? And I joke around. I say, look, you're probably not going to like this. A lot of my clients don't, because I keep killing off their loved ones in these scenarios to see where the money goes. And then we put in some layers of contingencies talking about the estate and where it actually goes after you're gone. And the fourth one, if they have minor kids, we run through who would you want actually raising the kids until they turn 18 and they're a legal adult.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
That's it. But too often I end up seeing the results. Well, who do you want to be the trustee? And here's what the trustee does. And here's how they handle things. And okay, well, let's talk about the power of attorney. If you become incapacitated and there are assets that aren't in the trust, let's talk about who would be doing it and who would be a better And so they draw this out, and they sometimes get paid 2 or 3 times as much if what they're doing is getting paid by the hour. Now, that's probably another subject for an entire other video of flat rate fees, which is what my office does for putting together the plan, versus getting paid by the hour to do all of this stuff. So drawing that out and having different people for all these different things ends up becoming a huge waste of time and a waste of the client's money, but hey, that money's going into their pocket. Second thing at the planning phase, overloading the plan with specific bequests. In other words, oh, well, I want this item to go here. Or I want this piece of property to go here. I want this piece of property to go here. I want this account to go here. I want these vehicles to go here. And they just start doing this as an asset-based plan rather than a percentage-based plan. So when I talk with my clients, I really encourage them not to start thinking about the stuff that they currently have and who gets it, and instead think about percentages that reflect no matter what actual items they have, You're deciding who your beneficiaries are and what they're going to get. The reason that some attorneys do this is because they know darn well within 3 to 5 years, about a third to a half or more of their assets have changed. Oh, we moved. Well, wait a minute. You had this house going to this person, so we need to come in and revise the plan. Oh, wait a minute. You no longer have this brokerage account because you got ticked off at your broker and you went to someone else, and now they have... Oh, well, we got to update that plan too. Well, all right. So these unnecessary changes come about not because you're changing your mind on who your beneficiaries are or what percentage they want to get. It's the items that just creates more chaos than is needed and ends up having you have to keep going back to the lawyer's office and pay them by the hour to make these updates. So if you stick with percentages, it's going to be a lot simpler and more longer lasting. Now, those are the planning end things. Here are some things on the settlement end that really end up ticking me off when I see it. Okay, when you see in anything with trustees, healthcare agents, financial, anything is just the worst idea that's out there. Everybody thinks, well, okay, if we've got my 3 kids, we'll make them co-trustees. We'll make them all co-powers of attorney. They can spread the work around. Oh, no, that's not what happens. What ends up happening is the banks, the financial institutions, they're a little nervous. Wait, we've got 3 co-trustees. We don't want to get stuck in the middle of some kind of argument among the kids. We're going to make all 3 of them sign everything. And then what you've done is you've kind of tripled the paperwork. And at the same time, if there's this dispute, well, let's go to the lawyer. If you go to the lawyer, they can settle this argument, and then we can pay them by the hour for this work. Okay, sometimes there are disputes that happen, but with my firm, it's not among co-agents. It's usually among the beneficiaries. There's one person in charge. It just makes everything run more smoothly. But I know that there are some attorneys out there that will make it anything because they know that there's a big percentage chance that something's going to blow up at some point along the way, and it's more legal fees. All right, so the 4th big thing that I see is just not using a revocable living trust. And this is really the biggest waste of money, is doing probate. I've kind of built my practice around trying to help my clients avoid probate. The key in that is a revocable living trust where you can solidify your entire estate plan in one place, and it's all there and it's all laid out, and everything is either in the trust or paying into the trust, unless there's a tax reason not to. We've got other videos on that. You don't want to put any tax deferred or tax-free accounts like Roths into a revocable trust because of the tax payout and all that other stuff. But by and large, you've got your whole plan in one place, and you end up funding that trust, and it avoids it. And there are just some attorneys out there that will not talk about it at all. Oh, well, they came to me and they said they wanted to do wills. And okay, well, we put together the last will and testament. That's the industry standard. And look, it's not the best and most efficient way to do it, but it means that the family's coming back to the law firm usually for probate work. And it's between 4 and 10%. In fact, go ahead, check out, I've got my free trust course. It's freetrustcourse.com, and it runs through all of this. And in particular, it's got my book, Estate Planning Basics, in there that runs through this. Probate generally eats up 4 to 10%, and it's extremely common for attorneys who do probate work to say, well, tell you what, here's all these papers you can sign and make us the executor or the administrator of the estate, and we just take 5% of everything. My clients, when they hear 5% of everything that they've worked for, that's like, oh, forget it. But a lot of the beneficiaries like, well, we get 95% and we don't have to do anything. Well, okay. No, it doesn't have to be between those two choices. It can be, look, avoid all of this by using a revocable living trust. And like I said, a lot of attorneys just don't talk about it. All right, so what now is the fifth thing? When you do have a revocable living trust, and you have to have a last will and testament, but the standard that it should be is, quote, a pour-over will. All the will says in the allocation and distribution section is, look, if anything does end up in probate, send it to the trust and the trust takes care of it. Done. I've seen attorneys duplicate everything in the will that was in the trust for all those allocation and distribution terms. And I've seen them intentionally leave out the personal possessions from being listed and going into the trust and being owned by the trust. So this guarantees that there is some kind of probate. And with that probate work, if it lists all those beneficiaries, suddenly all of those beneficiaries have forms that they have to sign that they're receiving this. They understand that they're a beneficiary. All their information is listed in the probate paperwork, and names, addresses, and their age. And it's all publicly disclosed. My clients even hate that concept, but the attorneys will intentionally put it into the will, knowing, well, okay, if they're smart enough to do a revocable living trust, at least we're getting something out of it, and we're expanding what we have to do for paperwork by making multiple beneficiaries. Look, if the will is a true pour-over will, and it says everything goes to the trust, the only person who has to sign off on all of this stuff for probate for what was missed and went into the probate estate, or there was nothing you could do about it, it's only the same person who is the executor, which is usually the trustee. That one person can go through all of this without involving the other beneficiaries in this paperwork mess called probate. All right, so now what is the sixth one? This is such a common practice, especially if you're not coordinating things like we try to do with in particular, the financial advisors and accountants and the other members of the team, especially if you've got a family practice or a digital family office, where we're all looking at everything. It's funding that trust. Okay, what good is a revocable living trust if it says, here's where I want everything to go, here's where the trustees are, and nothing gets put into it? It means all the assets that didn't go into the trust and are just sitting out there, they end up going through probate, which again means more potential work for the attorneys. A good, well-funded revocable living trust is going to keep so much of that stuff off the table and minimize costs, minimize frustration, minimize the length that the assets that do end up in probate actually have to be there. And it's, like I said, in the last one, you're not going to be listing all of the actual names, addresses, and ages of the beneficiaries. It's just the trustee and their address. It's minimizing all of that stuff that the lawyers don't have to do the extra paperwork for, where they get paid by the hour, or we'll just take the 5% as the personal representative and we'll do all this extra work for you. See, your trust wasn't funded. Oh gosh. This is where you end up seeing a lot of these attorneys, if they do get a revocable living trust requested by the clients, they give them a little kind of, here are your quote funding instructions. They don't even talk about it. And they go, here you go. Here's your binder. And they never address funding. They expect you to read through it and handle it on your own. There's no discussion of it. When we're working with clients on revocable living trusts, we actually have a separate funding meeting to really go through everything. And we come up with a custom personalized checklist, not a, here you go, here's just your funding guide that we're not really going to talk about. They only do enough to make sure they're covering their butts. So those are the 6 big things. Now, if you can think of more, please go ahead and put them into the comments on ways estate planning lawyers will actually expand what they need to do, especially if they're getting paid by the hour. And if you are interested in a full-on video about the pros and cons of paid by the hour versus flat rate fees, look, go ahead and put that into the comments. And if we get enough people who want that, I will go ahead and make that video a priority. So, as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.